All rise. The court is now in order. The Honorable Judges Sykes, Burns, and Traubers presiding. Judge Burns will serve as president. You may be seated.
We're convened here today for the oral arguments and the questions related to the subsistence use and trophy hunting, a case brought to this court by the states of Astor and Rishbach. The parties, by special agreement, have asked this court to decide the matter on the basis of the rules of conventional law and principles of customary and general international law. Are the parties prepared to proceed? Applicant, please proceed.
Good afternoon, Mr. President, Your Excellencies, and may it please the court. My name is Vikram Ramaswamy, and I rise alongside my co-agent, Ms. Catherine Shee, on behalf of the applicant, the state of Astor, representing Team 31. I will speak for 13 minutes on the first issue regarding Rishbach's breach of the Convention on Migratory Species. My co-agent, Ms. Shee, will speak for 13 minutes on the second issue regarding Astor's alleged breaches of CITES and the ARTA, and we respectfully reserve 4 minutes for rebuttal. Your Excellencies, this case is about protecting a critically endangered species in the Royal Markhor. The CMS establishes a presumption against the taking of even one critically endangered Appendix 1 species, unless one of 4 narrow exceptions in Article 3.5 are present. Rishbach attempts to justify their auction process through 2 of those exceptions, Article 3.5b, the conservation exception, and 3.5c, the traditional indigenous subsistence exception. It's Astor's position today that neither of those exceptions are met in today's case, and we respectfully ask this court to find Rishbach in violation of its conventional international law obligations. I'll begin with 3.5b, and I'll then move to Rishbach's 3.5c claim. To my first submission, Article 3.5b of the Convention on Migratory Species establishes that limited taking is permissible when it is for the purpose of enhancing the propagation and survival of a species. The crux of our position is this. Rishbach, through their auction process, only gives 15% of proceeds to direct conservation efforts, vaccination, and education.
Agent, can I please ask you, in that regard, to comment on the relevance of CMS COP Resolution 14.17 on the communities and livelihoods, which expresses parties' view that communities need to be supported in their rights to manage and protect migratory species. Doesn't that influence the interpretation of Article 3.5b in the sense that species conservation measures will often need to be intertwined with measures promoting the interests of communities? And should that be taken into account in the interpretation of this provision?
In this context, we don't think it should, Your Excellency. We do agree species conservation and trophy hunting itself may often be intertwined with other broader conservation measures. That being said, in Astor's view, the text of 3.5b for the purpose of enhancing propagation and survival requires funding to go to some of those direct conservation efforts, things like vaccination and education, rather than just a broad assertion that any limited trophy hunting management program is for the purpose of conservation. Such a broad view, we think, using that resolution to allow, for instance, any community-based management program to fit within the scope of this exception, in Astor's view, would open the floodgates. So if Rishmac, for instance, donated 1% of funding or $1 directly to conservation, if the thrust was very clearly subsistence or some other purpose, but there was still a management program present, by a view using that interpretation, that would fall under 3.5b, whereas in our view, 3.5b should be interpreted narrowly to exclude such an interpretation.
Agent, are you saying that there is a minimum percentage, a threshold percentage, and what would that be?
So while we don't think this court should set a strict numerical bright line, Your Excellency, something over 50% would almost certainly fall within this exception because that would clearly indicate the primary purpose was conservation. 40 or 45 would likely be a close question. That being said, 15% in our view cannot be stated to be for the purpose of conservation. This language of for the purpose is only present in 3.5b as opposed to any of the other three exceptions in Article 3.5 of the CMS. Similar language was interpreted by the ICJ in the Costa Rica versus Nicaragua navigation decision, and they came to the same conclusion that that language for the purpose of commerce excluded other subsidiary purposes from being considered commercial, that the primary or main purpose of a ship navigating down the San Juan River had to be to transport commerce as opposed to government or military business.
But Agent, isn't this a very different context? Could there not be a number of different purposes that together, that work together to support conservation?
So it is a different context than commerce, Your Excellency. Purposes could work together to support conservation. That being said, the majority percent of funding that is going to things like indigenous food, housing, clothing, even if those do happen to have downstream effects that have conservation benefits, things like better conservation management, we don't think those things would be for the purpose of conservation because purpose implies looking at the design, the original intentions or goals of the program, rather than merely the downstream effects.
Can I ask one more question and follow
Of
up to
course.
that? Given the special connection between the Dion Ginsu and the Royal Markhor, could we not say that purposes that support the economic survival of the Dion Ginsu themselves actually contribute to the survival of the species?
So we would say no, Your Excellency. I think a closer case that might help tease this out is to look at the auction or the program that was happening before the auction process was implemented, where hunting was done directly by Indigenous people using forms of Indigenous knowledge management. In that case, it might be closer to the sort of co-constitutive managing conservation and Indigenous rights and Indigenous subsistence as one. What we have here, we have hunting done by Astoria nationals using rifles after trapping female markhor in cement cages and using their urine to bait males. This sort of process we submit, again, even if it has some sort of conservation effect one way or another, cannot be stated to be for the purpose of conservation.
But Agent, wouldn't that perhaps have even a more salient impact because you're supporting a community that now has an incentive to engage in conservation measures and protect the species because there's substantial more revenue that's potentially being brought into that community and hence more of an incentive to ensure the viability of that species?
It's not, Your Excellency, because they had that same incentive before. The Diona Ginsu, we acknowledge, had a relationship with the Royal Markhor since time immemorial. They have relied on the species for forms of subsistence all through the past.
Agent, how do you get to decide whether they had more of an incentive before or not? Shouldn't that be something a determination they make?
Yes, Your Excellency, it may well be, but even if they make that determination that they now have a greater incentive to conserve the Royal Markhor, which we submit isn't in the record, but even if it was, we don't think that would still be for the purpose of enhancing propagation and survival. unless there was some evidence to indicate that Rishmac's purpose when implementing the auction problem or the auction process in the first place was that conservation goal, that they intended to facilitate this incentive.
Why do they have the burden of proof in this context?
Your Excellency, it comes from the language of purpose. Purpose is defined by Black's Law Dictionary or in any other broader context looks to designs or goals of programs rather than to downstream effects of things like, is there a conservation benefit after the program? The question rather is and should be, at the time the program was implemented or as the program is being implemented, is the purpose of the program conservation or not conservation? We think we get to purpose through looking at this funding split that very little of the money, 15%, is dedicated to the purpose of conservation. One final point on this question, though, before moving on to 3.5c proper. In this court's decision in the whaling in the Antarctic case, they looked to the question of necessity when dealing with the scientific purposes exception in the ICRW. Was the taking of hundreds of whales necessary to achieve Japan's scientific goals? And they said no, that more whales were being lethally sampled than were necessary. In this case, given that Rishmac is only giving 15% or 225,000 USD to the Royal Markhor, if Rishmac's auction process instead only allowed for the taking of 2 Royal Markhor or 3 Royal Markhor and gave a much larger percentage of that, 75%, say, that same $225,000 to those conservation efforts, you'd get all of the same stuff we've been having a conversation about. You'd get the same incentives, the same management program, you'd get the same money going directly to conservation, and 7 fewer or 8 fewer critically endangered species would have to be killed. So on that count too, we submit the killing of 10 critically endangered species per year is not necessary for these conservation purposes, even if those purposes ostensibly exist. So Rishmac's auction process cannot satisfy the text of Article 3.5b.
Does the text of Article 3.5b contain the word necessary?
It does not, Your Excellency.
Does that make any difference to how we should interpret it and apply it there?
It should not, Your Excellency. Even though that word necessary is not in the text, the preamble in Article 2 of the CMS both establish the object and purpose of the treaty broadly is to protect conservation, which means reading these taking exceptions narrowly. If it is possible to kill less Appendix 1 species than is being done presently and get the same conservation benefits or conservation goals, the whaling court said that's what we should do. We think the same thing is true here. Turning then briefly to the issue of 3.5c, because Rishmac independently claims the process is to accommodate the needs of traditional subsistence users of the species. The crux of our position is that this language, traditional subsistence users, requires the maintenance of the traditional relationship between the indigenous community and the Royal Markhor. We submit that that relationship, as defined in paragraph 14 of the record by the Dione-Ginsu community themselves, was a coming-of-age ritual where young men traditionally hunted the goats. They kept the horns, which had the most ritual and spiritual significance. That is...
The program supports the community's housing, food, healthcare. Are those not their needs?
Those are needs, absolutely, Your Excellency. But we submit that the language of traditional in Article 3.5 adds a modifier to the way this exception should be read. That
it doesn't say traditional needs, though, does it?
No. But it does say traditional subsistence users, Your Excellency.
Well, Agent, couldn't you equally construe that to be the needs of those that were traditionally subsistence users? They don't necessarily have to be engaged in subsistence at this point, do they, by those terms?
Your Excellency, we submit that traditional subsistence is a term of art, and that language...
On what basis?
Yes, Your Excellency. On the basis that that language is used across a host of various other conservation treaties, as well as similar principles such as Articles 25 and 26.3 of UNDRIP. All of these treaties derive this right of indigenous communities to maintain a relationship to natural resources like the Royal Markhor, or to maintain the relationship to land that they have traditionally owned.
Well, Agent, what precludes them from maintaining their connection to the land and their connections in the community? Indeed, the argument again is that the the money that's brought in from the auctions will allow them to maintain that kind of cohesiveness, right? Isn't that furthering the goal that you're espousing here?
It will not allow them, Your Excellency, to maintain their cultural and spiritual connection to the Royal Marquor that was done through the coming of age ceremony.
But Agent, that's a conclusion you draw. Again, shouldn't it be the indigenous community that gets to make that decision?
Your Excellency, I see my time is about to elapse. May I briefly answer and then conclude?
Yes.
Your Excellency, it's not a question that we draw for two reasons. First, paragraph 14 of the record is this community themselves and both parties agreeing that the traditional relationship of the Dionagensu to the Royal Marquor was the coming of age ceremony, was the horns. The horns are being taken by Astoria nationals, and so it's not our conclusion, it's just derived from the facts of this case. That being said, secondly, it is up to this court's judgment to determine whether the traditional relationship is maintained. We have jurisprudence, like the Diergaard versus Namibia case in the HRC, where they held there is a subsistence relationship. There is a need for the land to be maintained by this indigenous community, but their customs and the way they are using the land have shifted too far to make the preservation of that relationship culturally necessary. There is no cultural necessity in this case because they themselves have chosen to evolve their traditions away from this original coming of age ceremony. That's not protected by this traditional subsistence needs language in Article 3.5c. And so for the aforementioned reasons on both counts, we submit Rishmack is in violation of the CMS. Thank you.
Mr. President, Your Excellencies, and may it please the Court. My name is Catherine Shee on Team 31, and I too rise on behalf of the applicant Astor in the case at bar. Your Excellencies, this case is about the precarious balance between sustainable taking and further jeopardizing an already critically endangered species. The program that Rishmack is conducting is towing that line. And with that presumption against taking, as outlined by my co-agent, we urge this court to choose conservation, and therefore we have two submissions on the second issue before the court today. First, that Astor's import ban is not a violation of the CITES Convention, nor its object and purpose. And second, that Astor's import ban falls under both of the general exceptions in the ARTA and is further not arbitrary. To first then—
Agent, may I ask you to address the preamble of the ARTA? Which states that the parties resolve to promote broad-based economic development to reduce poverty. How should we interpret that preamble language and how should we apply it in our interpretation of the ARTA?
Yes, Your Excellency. As you and His Excellency have both recognized, the right to Indigenous people to cooperation in promoting economic development is informative, yes, but it's not determinative. So then going back to my co-agent's arguments, if there was a program perhaps that went to something like 60% funding for conservation and then 40% for Indigenous needs, which was the program conducted in Tajikistan, that perhaps would be acceptable. That's not what's happening here. That's why Astor has an interest.
It is reducing poverty.
Yes, Your Excellency.
Right?
But there are also goals other than that in the preamble of the ARTA, some of the goals which include conservation. And in the ARTA, explicitly in Article 20, it gives states agency to make that determination of whether or not there are public morals concerns, conservation concerns. So then moving into the first argument on the CITES Convention, if we look at the CITES object and objective in the preamble of the CITES Convention, it tells us that the ultimate goal is to reduce international demand for these endangered species. It's because of this international demand that humans are placing pressure on these species. They're going endangered in the first place. So while money can be important, that's not always as valuable as the impact from the ban that is the tangible and realized not taking of those 10 Royal Marquor Liza years. So yes, there's a
Agent, there seems to be rather good scientific evidence to indicate that reducing or removing trophy hunting actually tends to hurt conservation as it reduces incentives for local people to protect habitat and to tolerate the wildlife in question. If it pays, it stays, and vice versa. Isn't it difficult to defend then that the import ban serves a conservation purpose in this context?
No, Your Excellency, for two reasons. First is that there might be good scientific evidence that this isn't to the detriment of the species, but what, as my co-agent cited, is another important element, that the taking be in proportion to the realized benefits, which Your Excellency recognizes is the thrust of any conservation program. The realized benefits in this case is that there's no change in the status of the vaccine proposal, and there's already management programs going on in Rishmach. As cited in paragraph 18, I believe, of the record, or 16, there's already programs to prevent the mixing of domestic goats with the royal markhor, which prevents.
But Agent, there's other benefits beyond that come from trophy hunting, right? That the incentives for protecting the species that might not otherwise exist, and can't that be an independent, compelling reason to allow trophy hunting and comport with the principles of CITES?
It can be, Your Excellency, but we already know how that's incentivized them. What it says in the record is that it's incentivized them to give 15%, which isn't a primary purpose, and that hundreds of thousands of dollars hasn't amounted to any successful vaccine research. We know what the incentive looks like, and we know
but
that.
Agent, you're focusing only on the vaccine. I'm saying, as Judge Falrish did, if it pays, it stays. It provides an incentive for the tribes to protect the species, to not kill them when they may encroach on their land, and so forth, right? Is that goal not propagated by having trophy hunting and thus comports with the principles of CITES?
The first, Your Excellency, is that if the concern is preventing them from killing them if they encroach on their land, Rishmach already has a quota of 10. It already has a requirement that they don't take in excess. That problem is addressed. And if it's about
Yes, but the incentive is the money coming in from the foreign trophy hunters, and so it's not about necessarily the alleged benefits of having trophy hunting, but what are the consequences of taking the money flow away through this import ban?
Yes, Your Excellency. Per paragraph 14 of the record, the Daiohniaginsu have had a relationship with the royal markhor since time immemorial. They value the species. There's nothing to suggest in the record that by removing this financial incentive that they're going to start killing the royal markhor for fun or for anything that's other than protecting the species in their future, which is why this action.
But Agent, there were those traditions in places like India and some parts of Africa, and when some of those incentives were removed, within a decade or two, there was a radically different orientation of the people on the land to those species. Could that not happen here, and thus again justify providing the funding that comes from trophy hunting?
That might be true in that example, Your Excellency, but it can't be made as a generalization.
But who has the burden of proof then? If there's some precedent in the past and the only thing we see is the relationship of people to species, and that shifted after you eliminated those incentives, why should we buy your assertion without proof of empirical evidence otherwise?
Your Excellency, with all due respect, there isn't anything in the record to suggest that removing those financial incentives.
No, but there's
change
empirical evidence that in the past, when we've done this with other species, that's been the result, and that seems to be the most compelling evidence in front of us, correct?
That's incorrect, Your Excellency. That's one empirical example. There's also examples of the United States placing a ban on the import of hunting trophies from Zimbabwe and Zambia that incentivized the people to make protection so that they could restore the population to then a level that could be hunted first. It's not that one example. There are multiple examples, such as other ones in Belgium, Finland, Netherlands, that have better promoted conservation benefits when the import ban was in place. So while there may be concerns that one example might play a role in our case, what we know of the relationship between the Daiohniaginsu and the royal markhor and other successful import bans doesn't suggest that that's going to be the case here. So then to move into the ARTA. Astor recognizes that their import ban is a quantitative restriction in violation of Article 11. However, the ARTA in Article 20 provides two general exceptions. To address first Article 20G, the exception for the conservation of exhaustible natural resources. Per WTO jurisprudence, we consider three things. First, whether or not it's the exhaustible natural resources.
Agent, we are not bound to follow the interpretations of the WTO appellate body, correct?
Yes, Your Excellency.
So, in the ordinary meaning of the term exhaustible natural resources, would you say that that covers goats?
Yes, Your Excellency.
Why?
Goats are a natural species. They reside on this earth. The fact that they're listed as endangered means they've been exhausted. That's exactly how endangerment comes about. So even if we're just looking at that ordinary meaning, it's undoubted that an Appendix 1 species is an exhaustible natural resources. That's what the facts tell us. So even under that brings us to the second element of that conservation exception, whether the ban is related to the interest of conservation. And thinking about the ICRW's requirement that this be in proportion, the taking be in proportion to the realized conservation effects, we see that there isn't any protection of the virus, but there is that positive taking of the 10 royal marker per year. Astor's ban eliminates that per paragraph 31 of the record. And finally, the element under this conservation exception remaining is that it be in conjunction with domestic measures. What the WTO in the China raw materials case, though not binding, is informative given the identical writing of the text, tells us that the ban must be complementary with domestic measures. Per paragraph 14 of the record, there's already a domestic ban on the hunting of Appendix 1 species.
Agent, is there a ban on trophy hunting?
No, Your Excellency. But the requirement isn't that they be identical, but that they ultimately go towards the same purpose, that same purpose being conservation. Now, to move us then to the second exception, also under the ARTA in Article 20A.
Agent, I would like to ask you about the same issue in respect to 20A. If there's no ban on trophy hunting in Astor, then how can we conclude that trophy hunting is contrary to public morals in Astor? Would it not be banned in Astor if it was contrary to public morals?
Astor's submission before this court isn't simply that trophy hunting is our public morals. That's why we would like to submit before this court that our public morals interest, as defined, should be considered the trophy hunting of endangered species. The WTO, in accordance with their public morals interest, has allowed states to define what their own interest is. Now, that's not an unbounded allowance to do whatever you want in the name of public morals. That's where that second element under the test comes in, whether or not the ban is necessary.
Agent, let me ask you something related to that with the chapeau. Given the fact that you don't ban trophy hunting in your country, could that not be construed as creating a measure that's a disguised restriction on international trade to support domestic interests, right? Because in this case now, the domestic trophy hunting industry is given a leg up because you've banned trophy hunting from in other countries. Doesn't that violate the chapeau of ARTA?
No, Your Excellency. As refers to us specifically, we're considering the trophy hunting of endangered species.
But Agent, you're propping up the domestic trophy hunting industry by undercutting the trophy hunting industry in another country. Is that not a disguised restriction on trade that violates the chapeau?
No, Your Excellency. The impact on the trophy hunting industry in Rishmach, as stated in the record, is specifically the impact to the Diana-Ginsu community on endangered species hunting.
But ARTA's domestic trophy hunting industry now has a leg up because there's less competition from trophies that could come from other countries, and thus there's likely to be more trophy hunting in ARTA. And under the chapeau, that can constitute a disguised restriction on international trade. Doesn't that violate the chapeau, as the WTO has decided in a number of cases where domestic industry benefits from an international ban?
It's actually false, Your Excellency, to state that the endangered species trophy hunting industry in the ARTA is better off. They can't hunt endangered species per paragraph 14 of the record in Astor.
But
And
they can
even
trophy
if we're-
hunt more, right? And presumably if there's a demand for trophy hunting and now they can't do it in another country, it's likely to increase in your country, right? So couldn't it be that the domestic trophy hunting industry, given the fact you didn't ban it, you had the option to ban trophy hunting domestically, did not, they now have a leg up. Doesn't that violate the chapeau?
No, Your Excellency. Question 7 says that when we're concerning unendangered animals, the Astoria Nationals are not going to Richmond. They're already doing the hunting in Astor. There's no change in industry burden here, which means that the ban is not arbitrary. It's protecting that public morals interest. It's protecting its own people from having a hand in the taking of the lives of Royal Markhor in Richmond. That's the public morals interest. That's what we're fulfilling.
Agent, I'd like to ask you a question that probably is going to be the last one because you're almost out of time. The Royal Markhor itself, of course, cannot speak in these proceedings. If that was possible, if someone could represent the voice of the Royal Markhor here, what do you think it would say?
Yes, Your Excellency. Mr. President, I see that my time has elapsed. May I briefly answer and conclude? Yes, Your Excellency. If the Royal Markhor were here today, which Astor does attempt to represent through its arguments, I believe that the realized impact that the Royal Markhor see every year from the people coming to hunt them, chasing after them with guns, what they feel most closely is that the hunting is happening. We've already managed the spread of the virus. We've already managed other elements. What's not managed is the killing, and that's what the Royal Markhor experienced, and that's what Astor is standing against. We ask this court to find in favor of the applicant, Astor. Thank you.
Respondent.
Mr. President, Your Excellencies, good afternoon and may it please the Court. My name is Sarah Revillo from Team 87, and together with my co-agent, Denzel Mann, we have the honor of representing the respondent, Rishmak. I will be speaking for 15 minutes on our first submission that the auction process does not violate conventional international law. My co-agent will be speaking for another 15 minutes on our second submission that the importation ban imposed by Astor violates conventional international law. If Your Excellencies have no preliminary question, we will now proceed. Thank you, and may it please the Court. Your Excellencies, effective conservation demands balance, that while it strives to protect our endangered species, it also realizes the realities of human reliance upon nature. We will be discussing our arguments based on the order of the applicant's submission. Thus, contrary to Astor's claims, we argue that, first, the auction process is for the purpose of enhancing propagation or survival of the species.
Agent, I would like to ask you about that submission. Under principles of treaty interpretation, including the Vienna Convention, we must interpret the words of the treaty in accordance with their ordinary meaning. Is it really the ordinary meaning of Article 3, Paragraph 5b, for the purpose of enhancing the propagation or survival of the species, that killing them fits within that language?
Well, killing them does not necessarily fit in that language, Your Excellency. The usage of the definite article "the" has been guided by the CMS in their COP14, and COP14 Resolution Number 20 is a subsequent agreement or a subsequent application that also falls under Article 31, Paragraph 3 of the VCLT as an interpretative guideline for interpreting a treaty. And it provides that multiple objectives may coexist in a single act of taking, And to directly address your question, Your Excellency, as to the killing, taking under Article 1 of the CMS is defined as any act of taking, killing, hunting, gathering, capturing, and any other types of activities that may fall under this. So any type of activity that would take may have multiple objectives if it has an
Agent,
aspect.
please, building on the prior conversation on rules of interpretation, another rule obviously is that rules must be interpreted in line with object and purpose of the treaty involved. And given that the objective of the CMS is migratory species conservation, would you agree in general terms that as a universal rule of thumb, exceptions to strict protection should be interpreted narrowly?
Yes, Your Excellency.
And wouldn't that have significant repercussions for the scope of interpreting these terms, such as the percentage, the funding that is used, but also the necessity, etc.?
Yes, Your Excellency. However, the auction process of RISMAC does not depart from the object and purpose of the CMS. To provide our analysis, the auction actually is for the purpose of enhancing propagation or survival of the species.
But Agent, outside of the funding for the vaccine and things of that nature, how do the other components of the funding flowing vaguely to the community and food needs and things of that nature, how does that directly benefit the species?
Your Excellency, the community needs also inures to the conservation of the royal markhorse. Paragraph 1 of the record shows that one of the major threats to the population of the species is habitat degradation. And the auction, by funding the community needs of the Dayong Ginsu, such as housing, medicine, and food expenses, this lessens the Dayong Ginsu's needs to rely or exploit the natural resources in the habitat of the royal markhorse. This shows that there would be no competition with the royal markhorse in terms of their natural resources, thus reducing the threat of habitat degradation. And apart from addressing habitat degradation, Your Excellencies, the auction also addresses the major threat of disease, which the record shows is a threat that is prevalent among royal markhorse with a mortality rate that can go up to high as 30%. This shows, Your Excellencies, that if we apply the threshold that was provided by the applicant earlier of 50% to establish primacy, granted that the community needs is also for the preservation of the species, it would amount actually that 90% of the funding from the auction is for conservation of the species, Your Excellencies. What Astor is alleging to stop the auction process in itself is actually resulting to a case where the lone conservation program for the royal markhorse would have no funding at all. And if we may present two different scenarios of taking without an auction and taking with an auction, we can see that regardless, 10 royal markhorse are still going to be taken.
Agent, could I ask you to comment on another example that your opponents used? What if the funding that is specifically for conservation of the royal markhor, what if it was only 1% instead of 15%? Would your argument still apply?
In that hypothetical scenario, Your Excellencies, and 1% is evidently not enough to establish a purpose.
Well, then how can that be the case if you're saying that the money that goes to the Dayong Ginsu actually is for the conservation of the royal markhor?
Yes, Your Excellency, because it directly addresses the threat of the habitat degradation. While the 15% directly addresses the threat of diseases, the money going to the community addresses the threat of habitat degradation.
Okay. And would that not still be the case, even if the money for the vaccine, the percentage was only 1%?
Yes, Your Excellency, but in such hypothetical scenario, it would not establish that primacy, but what we have in this case is that the allocation scheme of 15% for vaccination research and 60% actually for the community needs of the Dayong Ginsu community would have a total of 90% actually being allocated for the conservation of the royal markhorse. And this establishes that purpose of enhancing propagation or survival, making the auction process fall under Exception 5B. Your Excellencies, it is in our position that conservation is a multifaceted endeavor. It does not only involve environmental concerns, but social concerns as well. and this leads us to our second argument, that the auction is to accommodate the needs of traditional subsistence users. The applicant argued earlier that the needs must be contemplated in its traditional context only. However, as Your Excellencies have properly pointed out earlier, Exception 5C reads, and I quote, to accommodate the needs of traditional subsistence users.
Can I
End quote.
please ask you, Agent, on the meaning of the term subsistence? There's also the meaning of traditional, but let's focus on one of them for now. Would you agree that not everything can be called subsistence, that there's a maximum to this term somehow, as we are obviously not subsistence judges on this bench, I think it would be fair to say.
Yes, Your Excellency.
So aren't hunts worth $100,000 or more, well above the maximum that you could, with any fairness, call subsistence hunting?
No, Your Excellency. While we recognize that the amount of selling the hunting rights of the royal markhors amounts from $100,000 to $150,000, we would like to highlight the nuance that only 10 royal markhors are allowed to be taken annually. And even if we apply the
But
higher...
isn't it about the money if we're talking about subsistence?
Yes, Your Excellencies. However, subsistence denotes for the basic survival of the community, and while there is an auction in place, this does not remove the fact that this is allocated for community needs such as housing, medical, and food expenses, which are within the core subsistence needs of the Dayong Ginsu, and there is nothing excessive about this, Your Excellency, even if we use the dollar amounts.
Could you perhaps mention a number that you would consider excessive?
Your Excellency, it would be excessive if it would be for profit. However, we don't have profit in this case because given that only 10 royal markhors are taken annually, even if we apply the higher amount of $150,000, this would amount to $1.5 million annually. And while that sounds a lot, there are 4,000 members of the Dayong Ginsu. As such, if we allocate that one...
Agent, we are all familiar these days with the term greenwashing, right? Isn't this program really of kind of indigenous washing of commercial hunting?
No, Your Excellency.
Why not?
There is nothing commercial about this, Your Excellency, because
There's nothing commercial about it?
commerciality, Your Excellency, as framed by the applicant earlier, is in the context of profit. However, there is no profit to speak of in this case.
Does the casino profit?
Your Excellency, while there is a casino that is involved, it is not for profit because it is merely an avenue for the Dayong Ginsu people to conduct this auction. If we may note,
How much money does the casino get from the
10%,
auctions?
Your Excellency.
And does the casino have expenses that offset that money?
Your Excellency, the 10% allocation from the proceeds is merely an operational expense for a more beneficial objective in this case, which is both the conservation of the royal markhors and also the economic needs of the Dayong Ginsu community.
Thank you.
We note, Your Excellency, that Rishmak is a low-income country, with the Dayong Ginsu community having the highest poverty rate, and there is no avenue within Rishmak in order to conduct this auction process apart from Astor, because Astor is their biggest clientele. The fact that it is conducted in a casino is merely a venue, but it does not depart from the fact that the proceeds are allocated for the royal markhors and for the Dayong Ginsu community. To circle back to our point earlier, Your Excellencies, of the allocation of the funds, $1,500,000 allocated to 4,000 members of the Dayong Ginsu community would only amount to $375 per member per year. Surely, Your Excellencies.
What would happen if now there's a quota of 10 per year? What if your country decided to increase the quota to 15? Would all of this still apply? Would it still be fit in with that exception for traditional subsistence users?
Your Excellency, allow me to address your question in two layers. Firstly, in that hypothetical scenario, it would not apply. But what we have in this case is that there are 10 royal markhors being taken. Secondly, the taking of the royal markers in this case is not the issue that is being contended by Astor. Paragraph 19 of the record shows that Astor never really had any complaints about the taking of the royal markers. It is the auction that they had an issue with. In fact, when the Dayon Ginsus were taking the royal markers, 10 are being taken, and Astor was completely fine with it. With the auction, 10 royal markers are still being taken, and then suddenly Astor is complaining. This shows, Your Excellency.
But now there is a community that's getting a stream of income. I think it's logical to think that community might have an interest in increasing that income. So isn't there pressure that might, other things being equal, cause more royal markers to be killed?
No, Your Excellency. In fact, with this auction in process, the Dayan Ginsu communities are more incentivized to protect the royal markers because they see the value of the species to be able to address, not just to preserve the species in itself, but also to address their community needs. Moreover, the applicant argues that the culture of the Dayan Ginsu people had been removed. However, this culture may not be defined by the applicant, but by the Dayan Ginsu communities themselves. Article 1, Paragraph 1 of the International Covenant on Economic, Social, and Cultural Rights provides that all people have the right to self-determination. It further defines self-determination to be a right to freely determine, decide upon, and pursue one's economic, social, and cultural development. Your Excellencies, culture is not static. It is meant to evolve, and this evolution is defined by the community themselves because they are the best judges of what is right for them. And paragraph 16 of the record shows that it is precisely the Dayan Ginsu community who decided to initiate the auction. It was not imposed upon them. This shows that the Dayan Ginsu community has their own prerogative to decide that the auction process is consistent with their economic development and also with their cultural
The
development.
question of who decides, let's say, on the other key term here, the traditional, would you say that it is also exclusively the Dayan Jinsu that are supposed to decide what is traditional, in be it moving from traditional bow to crossbow to rifles?
Yes, Your Excellency. It is also the Dayan Ginsu to decide what is consistent with their tradition. And with the auction in place, where they have already decided that this is consistent with how they traditionally view their values and their culture, then
Would there be... Go ahead.
Agent, would they then, by extension, would they have a right to ultimately decide to extirpate the species?
Sorry, Your Excellency.
Would they have a right to decide that they just wanted to eliminate the species at some point in the future? If there would that emerging cultural norm be acceptable? Should the international community have to accept that?
Your Excellency, I see that my time is up. May I ask for a brief extension? No, Your Excellency, because the right to self-determination is also limited by obligations under international law. However, there is no such issue in this case because there is no violation of the CMS by the Dayan Ginsu community. Your Excellency, the auction process not only complies with the CMS, but it very embodies the core principles of conservation, that is balance between environmental concerns and economic concerns of our indigenous people. Richmac's auction program is exactly that, balance. After all, Your Excellencies, conservation is not a zero-sum game. If Your Excellencies have any further questions, I shall now cede the podium to my co-agent. Thank you, and may it please the court.
Mr. President, Your Excellencies, good afternoon and may it please the court. My name is Denzel Mann, second agent for the government of Richmac. For the next 15 minutes, I shall be speaking on our second submission that the importation ban violates conventional international law. If Your Excellencies do not have preliminary questions, I will now proceed with my submission. Thank you, Your Excellencies.
The range of the royal markhors once extended over 6 countries, but as we speak today, it only now lives in 2, Astor and Rishmak. And therefore, as the last remaining range states, there is an imperative to cooperate and work closely together to conserve the species. And yet Astor imposed an importation ban that defunded our conservation programs intended to save the species. And in paragraph 33 of the record, they already conceded that such importation ban is a violation of Article 11 of the Astor-Rishmak Trade Agreement, or the ARTA. However, they allege that such importation ban is justified under the general exceptions in Article 20. So now, guided by the case of US gasoline, Astor has the burden to prove that such importation ban is justified under the exceptions.
Agent, we're not bound by that decision. Why, from a policy perspective, should we establish the burden in that way?
No, Your Excellency, this court is not bound by that decision. However, what is binding between both of the parties is the Astor-Rishmak Trade Agreement, and Article 25 thereof says that the WTO framework, the cases thereof, are subsidiary means of interpretation.
Right, they're subsidiary means, but they're not controlling. Why, from a policy perspective, should the burden of proof be ascribed in the way that you're saying it should?
Your Excellency, aside from the fact that Article 25 provides that such could be used, we also note that the nature of this case, Your Excellency, is a trade issue, and therefore the WTO might be considered as a qualified source of authority, Your Excellency, for this case.
Yeah, but why should the burden, from your perspective, from a perspective of making an argument, why should we ascribe the burden of proof in the way that you're saying we should?
It is because, Your Excellency, the general rule is that quantitative restrictions are prohibited under Article 11 of the ARTA, and therefore the invoking state of this narrowly construed exception should have the burden to prove that such quantitative restriction generally prohibited under the Article 11 is justified under the exceptions. Your Excellency,
Does your country have a right under international law to force Astor to accept importation of something that they deem to be morally objectionable?
Your Excellency, we note that this may refer to the Article 20A exception, which concerns the public moral issue as a justification. While we agree with Her Excellency that Astor could define for themselves what a public moral issue is, this is limited, and the same should be scrutinized under the WTO framework because they are using such public moral issue as a justification for a generally prohibited quantitative restriction. And hence, Your Excellency, we submit that such importation ban is not necessary to protect public morals. Allow us to discuss this in turn. Your Excellencies, to establish necessity, in the case of Columbia Textiles, there should be 3 factors that should be weighed and balanced. This being, first, the relative importance of the value at stake. Second, would be the measure's degree of contribution in addressing the public moral issue. And third would be the trade restrictiveness of the measure. The first factor of necessity is the relative importance of the value at stake. Guided by the case of Columbia Textiles, the analyzing relative importance includes an inquiry into a state's legislative history and its international law obligations. As to Astor's legislative history, the bench has properly pointed out that Astor failed to prohibit trophy hunting within its own territory. This is contrary to the case of Columbia Textiles, where the appellate body of WTO has held that indeed money laundering was a valid public moral issue for Colombia because that same act is a criminal conduct under their penal code.
But Agent, it seems like the public moral here is that they want to prohibit trophy hunting in endangered species, right? It may be a subcategory, but it seems like an extremely important one. And should not a state under principles of sovereignty have a right to make that declaration?
We agree, Your Excellency, that it is within the sovereign powers of a state to declare for themselves what a public moral issue is. However, we note that such authority is limited by the conventional international law in which the Astor is a state party to, such as the ARTA, Your Excellency. And we note, Your Excellency, that as to the international law obligations of Astor, they are state party to the Astor-Rishmak Trade Agreement.
Yeah, but Agent, ARTA provides for exceptions, which both sides have agreed, and one of the exceptions is public morality. And if the public sentiment as expressed by the legislature in this case, the surveys and so forth, indicate that this country does not want to import endangered species that have been trophy hunted, doesn't that comport with their obligations under the treaty and also any reasonable definition of public morality?
No, Your Excellency, because the quantitative restriction would still not be justified. It is in our submission that it fails.
But then you acknowledge that it does fit under the first two things that I've said. It fits under the terms of the treaty, and it fits as something that we could acknowledge could be public morality, right? So,
Yes.
So what you're maintaining is it all comes down to your third criteria now, right?
Yes, Your Excellency.
Okay.
We could see that indeed animal conservation, animal welfare are valid public moral issue. However, such quantitative restriction should still be construed and scrutinized under the framework.
So on that topic, could you perhaps comment on the influence of the increased importance of the notion of intrinsic value of wildlife in this context, both at the conservation of the species level and at welfare of individual animals, as perhaps the prolonged suffering, to illustrate, of animals during hunts was deemed acceptable 100 years ago. But that has changed, hasn't it? And how does that factor into the interpretation of the clauses we're discussing?
Your Excellency, I shall address your question in two layers. On first layer, at the outset, we note that the animal cruelty and pain suffering are not a public moral issue raised by the state of Astor. But on a second note, Your Excellency, nothing in the record provides also that there is an inhumane killing of the royal markhorse in this case, Your Excellency. And therefore, we should look in the main contention before.
Agent, is that correct? I understood that in about half of the hunts, they may be shot and then continue living for about 3 hours and need to be shot again. Is that not correct?
Your Excellency, it is correct. It was provided for in the clarifications in the record.
And are they not suffering?
Your Excellency, it is in our submission that suffering may be subjective, but in this case, Your Excellency, nothing that was stated in the record provides, Your Excellency, that such issue was raised or was identified categorically, Your Excellency.
Isn't it a matter of common sense that an animal that's been shot and then takes 3 hours to die is suffering?
It is, Your Excellency. However, even assuming, without conceding, Your Excellency, that that animal cruelty factor is something for this court to adjudicate, which was not raised by applicant, we still submit that the quantitative restriction solely on this basis is not enough to invoke the public morals exception to this case, Your Excellency. This is because there are other factors to consider. And aside from the first factor, which is the relative importance, which we submit that Astor failed to prove that such value or that such public moral issue is indeed important to them by failing to prohibit trophy hunting within their territory. There are also two other factors. This being second would be the degree of contribution of the measure in addressing the public moral issue. Astor claims that the refunds made to the Astari nationals are proof of this degree of contribution. However, we disagree, Your Excellency. It is because the Dayan Ginsu already has a vested right to take 10 species, and therefore, even without the importation ban, Your Excellencies, still 10 royal markhorse would be taken, and hence we note that the importation ban does not actually contribute to their main issue, which is the killing of the internationally protected species in this case.
But Agent, doesn't trophy hunting raise different moral concerns from traditional hunting by indigenous hunters? The evidence we have about public opinion suggests that there's something about hunting for bragging and showing off that you got these big horns that the people of Astor find particularly morally objectionable.
Your Excellency, we submit that traditional hunting is still incorporated in the whole auction trophy program, as could be gleaned from the record.
Right, but Agent, if this is just the perception in this country, do they not have a right under the ARTA exception to embrace that perception, right, as their public morality, right? It may not be what you agree, but is it an objective test or a subjective test?
Your Excellency, it is an objective test. Astor has the right to define for themselves what a public moral issue is, but it is limited. However, what is limited, Your Excellency, is the quantitative restriction that they are supposed to impose to address this public moral issue. Such quantitative restriction, which is the importation ban in this case, should be scrutinized under the necessity test, Your Excellency. And the third factor of that necessity test, Your Excellency, would be the trade restrictiveness of the measure. We note that there is no more restrictive measure than a complete ban of the importation of hunting trophies. And a quick overview of WTO cases would show that the WTO appellate body has never upheld the validity of a challenge measure or a complete ban that does not have any exception at all. Clearly, therefore, Your Excellency, for being the most trade restrictive measure that they impose, such bans should be held as not necessary for being highly trade restrictive.
Agent, I'd like to ask you about something the WTO said with regard to public morals and animal welfare. The panel in the seal products case said that animal welfare is an ethical obligation for humanity in general. Do you think there are ethical obligations of humanity generally towards the Royal Mark Corps, and what are they, if so, and how should they feed into our interpretation of these provisions?
Your Excellency, the Easy Sales product in fact supports our case because what the Easy Sales case did was to put the animal welfare and animal conservation under the ambit of the discussion of international law instead just of being a mere domestic topic, Your Excellencies. This is why any measures imposed by a state concerning animal welfare and animal conservation should verily fall under the scrutiny of such frameworks, Your Excellency. And to directly address your question, we agree, Your Excellency, that there is a valid public moral issue specifically to the hunting of the Royal Mark Corps, but also it is intertwined with other species. Hence, we note, Your Excellencies, that the failure of Astor to ban domestic trophy hunting undermines the genuineness of their public moral issue presented before this court. Your Excellency, Astor also invokes Exception 20G, an exception relating to the conservation of natural resources. And based on WTO framework, this has two requirements. First, that there should be a genuine relationship of the measure to the conservation, and second, that it should be made effective in conjunction with domestic restriction. On the genuine relationship, Your Excellency, the case of U.S. shrimp provides that there should be a genuine, close, and direct benefit to conservation.
Agent, we are not bound by that interpretation, and I would put it to you that the ordinary meaning of relating to does not require a very close connection, and on any ordinary understanding, this ban is relating to conservation of the Royal Mark Corps, isn't it?
Yes, Your Excellency. However, to illustrate, Your Excellency, what a genuine relationship might be, the U.S. shrimp may provide.
But why should we
guidance.
accept that there needs to be a genuine relationship? It's just relating to. It's certainly relevant to conservation of the Royal Mark Corps, isn't it?
Yes, Your Excellency. But it is not just the genuine relationship that we should look at, Your Excellency. It also includes, or the court is not precluded to looking at the predictable effects of such measure with regard to the conservation. And as we discussed, Your Excellency, the importation ban is counterproductive to the conservation because it defunded our conservation programs. But even assuming, without conceding, Your Excellency, that such importation ban indeed has a genuine relationship, there is a second requirement, which is it should be made
Agent, because you're almost out of time, I would like to ask you the same question I asked your opponents. If the Royal Mark Corps could speak here today, what do you think it would say?
Your Excellency, if the Royal Mark Corps were to speak here today, it will tell the world that the traditional relationship with the Dayan Ginsu is paramount. And therefore, the Royal Mark Corps and the indigenous community in which they are valued should coexist together, and the conservation thereof could be balanced, Your Excellencies.
Thank you.
If Your Excellencies do not have further need of my assistance, I thank this court for its time and indulgence. May it please the court.
Thank you.
Your Excellencies, and may it please the Court. I rise a final time on rebuttal to address the issues presented before the hearing by the respondent. I have three submissions. One is an overarching overview, and then one on each issue. First, both agents for respondent touch on the idea of habitat loss, saying that ensuring the Dionysians who continue hunting promotes that Astor's actions aren't going towards that concern. As a matter of fact, Fitzgerald notes in his analysis of habitat loss and in its contribution to in the endangerment of species notes that it's the act of hunting itself that drives animals away from their habitat. We know that from the record in paragraph 1. It's the hunting that is contributing, and if we allow the continuation of this hunting, that will further reduce that habitat. So then moving into the arguments presented to us by respondent on issue 1. Respondent says first that the habitat loss is promoted by those interests, and as just mentioned, that's not being fulfilled. And under the framework that respondent gives to us, if even 1% was given to conservation and 49% was given to the community without any evidence of any benefit, that would still go to the propagation and survival of the species. But what that hinges upon is ultimately the survival of the species. And what that trophy hunting is doing is taking 10 lives and driving them away from their homes. Now moving on to Article 3.5c on the traditional subsistence exception. The respondents say that it's up to the Dionysians to decide what their tradition is. So then let's see what is traditional as defined by the Dionysians themselves at paragraph 14 of the record. That states that their tradition is that coming of age ceremony where they're keeping the horns, they're doing the hunting themselves, they're the only ones involved.
But Agent, what do you make of their point that traditions evolve and change with time? And if I can do a double question connected to that, there's an indigenous nation in the area where I live, and one of the things one of their leaders said is, we don't have any tradition of starvation and poverty. They are using this program to support their survival, their economic survival. Is that not tradition?
Yes, Your Excellency. To respond to each of your questions in turn, on the first on evolution, what we're submitting is not that evolution isn't permitted, but as the HRC has held in the Diergaard case, what they've held in the Landsman versus the Netherlands case, and as well as in the Marika versus Sweden case, the essential core purpose of that tradition, that coming of age ceremony, is what's supposed to remain constant if we're preserving tradition. And then to your second question on the problem of starvation, what Astor is saying isn't that they can't conduct this program at all, but that if they're going to be doing it, we want this to be in line with those very narrow CMS exceptions. If perhaps it was a different balance on what was happening, a different balance on the amount of money, then that question would be different. But when it's 15%, when they've departed from that tradition, it's Astor's submission that that's not what's happening here. It doesn't follow under those exceptions. To then move briefly to issue 2 on Astor's import ban. Respondent concedes that Astor is free to define their public morals interest. And as we stated before this court, our public...
Can I ask you to comment on the relevance of the principle of common but differentiated responsibilities in this regard, as laid down, among other things, in Rio Declaration Principle 7. We have here a developing state that has a lot of trouble funding conservation and funding basic livelihoods, which comes up with a solution that works for local communities and for conservation. Shouldn't that be factored in a very considerable way into the interpretation of the law we are discussing?
I anticipate that my time has elapsed. May I briefly answer and conclude? Yes, Your Excellency. While there's differentiated responsibilities, what you said, as Your Excellency mentioned, is that we look to programs that have been proven to work for communities. This program's been going for 7 years. It hasn't worked towards conservation. So what Astor is essentially submitting is not that there can't be a program that works, but that this one doesn't work, and that they don't want their nationals contributing to the hunting. That's the concern. That's the point of the ban. That's the point of our first submission on the first issue as well. We ask this court to find in favor of the applicant, Astor, on both issues. Thank you.
Thank you. This hearing is now concluded. Thank you. Please be seated. You're going to kick it off, right?
Do we do the results first, or do we do?
Oh, we don't do the results.
Okay.
That gets announced subsequently, which is me. And so we're making general comments. They don't certain events when the result is. We make comments that don't prevail. Okay.
All right. I think we are no longer inhabiting the persona of judges. So I can quickly introduce my real self. My name is Katie Sykes. I'm a professor at Thompson Rivers University, Faculty of Law in Canada. And oh my God, you were absolutely amazing. The quality of advocacy that I saw here today was unforgettable. Congratulations to all of you. And I was a judge in a previous round, and I was really impressed with the quality of the presentations yesterday as well. I think you're all amazing. Really just blown away. I have some individual comments, but they're mostly just variations on the theme of you're wonderful and you have spectacular careers as advocates ahead of you. So number one, I'll just read a few highlights that I was writing down. There's a lot of exclamation marks and sort of enthusiastic adjectives. Your pace was great. You had good eye contact with us. You set out your argument very clearly. You had very good answers to the questions. And it says here, truly fantastic, eloquent, and spectacular. Applicant number two, another very good one. You knew the record extremely well. All of you had very good command of the facts and the very complicated layers of provisions that were at issue here. Your argument was very persuasive, also good eye contact, very clear responses to the questions. You stood up to some grilling from the bench and you held your own. And I thought that your answer to my final question, that was a bit of a left field one, was excellent. It was actually quite moving. So congratulations on handling that so well. Respondents, number one, also very clear, very confident, great pace. You handled all of the technicalities of the argument extremely well. You were self-possessed. You had some really great answers, you just came up with some very well thought through answers to difficult questions. And you landed it really well, which I think is one of the toughest things to do, to sort of bring it home at the end when we've been throwing you off course the whole time, and to just bring it back to the overall theme of your argument. And respondent number two, you were also very clear, very confident, great pace. You were very thorough. You were really good at sort of walking us through all of the steps in the argument, handled the questions really well. You also handled my question about what the Royal Mark would say very, very thoughtfully and very deftly. All of you were fabulous. Congratulations.
It was also a tremendous pleasure for me to play this role in this competition. My name is Arie Trouwborst. I'm a professor of nature conservation law at Tilburg Law School in the Netherlands. And both in terms of the topic of this competition, which was also really well done. So shout out to the team behind all this, personified partly by this beautiful fantasy creature on our left, your right. Like my colleague, I'm incredibly impressed with the quality of your pleading before us today. We don't have much of a not as strong of a moot court competition tradition in Europe as you do here and in some of the countries you are from. But I'm just so impressed with the way you present. You hold your composure under pressure. You get these wide-ranging, unpredictable questions from very different people with different personalities fired at you. And you must keep track of your train of thought, what you had in mind, and tie it into that. Also referring back and forth to what others have said, also what other judges have said individually. You also did that very well. While you are under stress and keeping on top of your substantive arguments. Also, just not showing at all how happy or unhappy you are with certain questions. That's part of this game. All four of you did that extremely well. Yeah, that's it for me for now.
Yes. Sorry. Yeah, I thought you were both fantastic. Your tributes to your country should be proud of you. You'll be great advocates for whatever you pursue. And so just a couple of very, very general comments then, because I think I concur with everything I've heard already. In terms of the applicants, I thought you were particularly strong in being able to draw on what isn't precedent, but what are analogous cases in other contexts, and explaining how they applied. I thought that was quite clear. I thought the rebuttal was really well done. I think rebuttals give a team, an applicant, a tremendous potential advantage, not only in terms of speaking last, but really being able to respond directly to some of the arguments and try to turn them right. But the rebuttals are often done badly, and sometimes are not helpful, counterproductive. This was very helpful, and I like the idea of starting off with kind of an overarching sort of argument, and then that supports your grand position, and then moving to what I thought were two extremely important issues that needed to be addressed, and doing a good job of addressing them. So that was well done in terms of the rebuttal. You're both great speakers, extremely well poised, especially again taking a lot of questions, and sometimes people asking you to move outside of your comfort level in terms of where you were in your organization, right? That's going to happen, right? So it's good practice, but you did it extremely well. Respondents, again, extremely poised, lots of questions to deal with too, right? You've got to be more tired than is imaginable at this point, right? But you did a great job of holding your composure and answering those questions well. I thought you were extremely well organized as a team. I like especially the fact that you worked through elements of tests and did those extremely precisely and extremely well in terms of explaining it. And that can be a bit of a trap, because that lets a court jump on each one of those, right, and try to niggle with them, right? But if you prevail on all elements of that test, right, it's kind of a lead pipe cinch that you've won that argument, right? So it's a good thing to do, and I thought you did extremely well with that. So I again thank you to both teams, and best of luck in the future. Safe travels home.
Thank you, and thank you for coming today and flying out to help judges as well.
It was an absolute privilege.
Pleasure.
Please do our final panel. Thank you so much. So, got some thank yous and then recognitions and awards. With some of the thank yous, we'd like to thank the Environmental and Land Use Law section of the Florida Bar for its generous support, and also the Environmental Practice Group from Mechanic, Nunzio, Hearn, and Wester, which is headed up by Frank Hearn. Frank Hearn actually. He was an original sponsor, financial supporter of the 1996 Moot. So he's a longtime supporter, and he now practices with his two sons, Ken and Travis, both Stetson Law grads, and they all support this competition. So we thank them very much. Of course, we'd like to thank all of the regional and national coordinators, especially those first-time coordinators from Tanzania. Anna Kalonzo. At Stetson, this is very much a team effort that is supported by the faculty, the staff, administration, the students, and the alumni in our broader community. A few folks and departments to point out, in particular, Janice Strawn and all of the faculty support office. All of the folks in facilities who helped set up our various rooms, and of course our media services team with us today, Dan and Jason, with taking care of the live web stream. So thank you very much, everyone. And now we'll move to recognizing each of the teams. And so I'll call you up, and we have certificates for everyone. Team 11, Institute of Professional Legal Studies, Queen's University, Belfast. Team 13, Ukrainian Catholic University Law School.
Thank you.
Team 21, Educational and Scientific Institute of Law of Taras Shevchenko, National University of Kyiv. Team 24, Mackenzie Presbyterian University. Team 30, also from Brazil, Federal University of Bahia. Team 31, University of Chicago. Team 37, Tribhuvan University from Nepal. Team 43, National Law University, Jodhpur, India. Team 53, Handong International Law School, Republic of Korea. Team 56, Law Society of Ireland. Team 63, OP Jindal University, India. Team 75, Chapman University, United States.
Thank you.
Team 81, Singapore Management University.
Thank you very much.
Team 82, University of San Carlos, in the Philippines.
Thank you.
Team 87, University of the Philippines, College of Law.
Thank you.
Team 92, Javeriana University from Colombia. Team 93, Singapore Management University, Yong Fong High School of Law.
Thank you.
And Team 97, University of Dhaka from Bangladesh. So we're going to recognize, and we had to make a cut somewhere, but it was the oral round scores were quite incredible, and so very much bunched at the top. So we're actually going to award the top 10 oralists in the preliminary rounds. And number 10 is Cathal Mullen from Institute of Professional Legal Studies, Queen's University, Belfast. Number 9 is Samarth Srineva from OP Jindal. In absentia. All right. Number 8, Angelica de Dios Mercado from the University of Philippines. Number 7, Emily Davis, Law Society of Ireland. The 6th top oralist, Anastasia Savchuk, Ukrainian Catholic University Law School. And number 5, Yulia Karkusha, Ukrainian Catholic University Law School. The 4th top oralist in the preliminary rounds was Catherine Shee, University of Chicago. The 3rd top oralist was Ayush Bandari from Tribhuvan University, Nepal. The 2nd best oralist in the preliminary rounds was Sarah Lynn Dato Revilo from the University of Philippines. And the top oralist in the preliminary rounds was Graham Lee Leon Cao from Singapore Management University. Moving on to the memorial awards, we have top 3. The 3rd best memorial was Team 93, Singapore Management University, Yang Kong Howe School of Law.
Okay, thank you.
The 2nd best memorial was Team 87, University of the Philippines, College of Law. Come apart. Just come apart. Yeah, yeah.
Okay.
Yep,
They have
yep.
to be very careful with
Yes,
this.
yeah. We have boxes. We have the boxes for you.
Okay.
Yeah, one for the school there.
Thank
Mhm.
you. This is beautiful. Thank you. Oh yeah, this kind of lovely.
And the top memorial award goes to Team 82, University of San Carlos. You also have the book. Carefully come apart.
Oh, it's so heavy.
And also we have as an additional award a book by Judge Katie Sykes. Yeah, I can move on. Oh, slide that way. Congratulations. Then each year we also give out a Spirit of Stetson Award that goes to the team that is friendly, collegial, and is just consistent with the spirit of this competition. And we ask each of you for your input. And we also get input from students and others with whom you've interacted. And this year, the Spirit of Stetson Award goes to Team 56, Law Society of Ireland. And so why don't you take out one of the maps? You get that, but actually the map is coming out. So here, we'll take a picture with one of the maps.
Wow. Amazing. Thank you so much.
Best of luck getting that home.
Thank you so much.
Oh. And we all appreciated you teaching us some Irish in the opening event. All right, we'd like to recognize the quarterfinalists. First, Team 37, Tribhuvan University from Nepal. Another quarterfinalist was Team 43, National Law University, Jodhpur. Team 75, Chapman University, Daly Flower School of Law.
Thank you.
And Team 81, Singapore Management University. our semifinalists, Team 82, University of San Carlos. And the other semifinalist was Team 93, Singapore Management University, Yang Fung Hao School of Law.
Thank you.
So the judges, I think, as you know, were quite enthusiastic about your performances, and it was very, very close. But the runner-up is Team 87, University of the Philippines College of Law.
Thank you.
And the champions of the 29th Annual Stetson International Environmental Moot Court Competition is Team 31, the University of Chicago.
Oh. Sorry.
And the best oralist in the championship round was Sarah Lynn Dato Revillo from the University of the Philippines.
Thank you.
So just a couple of other quick comments before we have pictures. You've been very patient. They'll want pictures with you, and of course you'll want pictures with the Royal Marquardt. So first, I'd like to thank the two folks that I worked with to put this on, Professor Aaron Okino and Professor Kat Pratt. Please give them a round of applause. Not too long ago, I got an email that every professor loves to get. It's from a student that they've worked with in the past, and so I received an email from a student who had from Kenya who had participated in this competition in 2018, and she said it was instrumental in shaping her path. She's now working in Paris with UNESCO. And so, you know, the Stetson International Environmental Moot Court Competition might, you know, it may change your career path, or it may not, and that's okay. But at a minimum, I expect that the skills that you have honed, the advocacy skills that you have honed, will serve you well no matter what you choose to do with your life and what area of the law you focus on. And I hope that the experience has created bonds and friendships, not only among your teammates with whom you have worked so hard with over the many, many months, but also with your new Stetson IEMCC colleagues that you've met this week, and now I hope are friends across the globe. So thank you all for participating.